This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm Noah Ballmer, your host, and today I'm excited to speak with Jonathan and Erik Bernstein. This father-son duo run Bernstein Crisis Management. Founded in 1994, the firm provides crisis management strategies to a diverse client base in areas ranging from business continuity to reputation management. Thank you both so much for joining me here today.
Yeah, thanks for having us.
Let's jump right into it. Jonathan, tell me a little bit about Bernstein Crisis Management. You founded the business in the 90s, but prior to that, you had already been working in the field. Is that right?
Yes, for 5 years before I started this business, I created and ran the crisis communications group for Reuter Finn, which is one of the top firms in the world. And it was the first crisis group they'd ever had, because back then, not a whole lot of people were doing crisis management full time.
Is that right?
I was told it wouldn't be possible to make a living doing it full time. They were wrong, but that's what I was told back then. And so, yes, I had that. And I worked for a number of other PR firms and corporations before that.
Has it always been a passion of yours?
No, actually, no, it's almost accidental. I started off 5 years in the military. I was an oxymoron. I was in military intelligence. And then I got in, became a journalist for 5 years because my investigative skills were useful there. And just someone suggested PR was a good way to go if you already had the writing and talking skills and so on. And it so happened that the first PR job I had was a company in the midst of the worst crises of their life, and I found I had a knack for dealing with it. It was Playboy Enterprises in 1982, and they were selling off the whole company, and Christie took over, and Hef retired, and it was just bad news after bad news, including the final press release was announcing a 40% reduction in force, including the entire PR department. So don't call me because I won't be here. But I found I had a knack for thinking when people are shooting at your feet, literally or figuratively, both from my military and civilian days. Right. And I found that of my 4 kids, Erik had the knack as well, and then he could just be trained to be better at it.
Erik, how and when did you first become involved?
I really didn't know I wanted to do this starting out. I was halfway to becoming a teacher, probably an English teacher. And then I really came into it because I was just using social media, really, in the advent of modern social media, MySpace and all of the copycats that were born out of that. And so I got a little taste of it, doing some basic social media work, some basic writing for Bernstein Crisis Management, and realized, hey, this is going to be a lot more interesting and possibly a lot more fulfilling in a number of ways than teaching would have been.
It's a really interesting subject matter to come up from as an expert witness. Let's talk about expert witnessing. It's interesting to have you both on because, we can draw some comparisons and distinctions between both of your experiences. I'd like to hear from both of you about how you were first engaged for your very first gig. Tell me about the call. Is it something that you had prepared for? Were you advertising actively in any way, or were you just contacted out of the blue?
Well, in my case, because I was the first one retained for one, I was contacted out of the blue by Roundtable Group. I had been trying on my own to land some work of that type and listed myself at various places, but I didn't know one from the other. But we were very visible online, and I'm assuming that's where Roundtable Group found us. And then I went through your screening process, and that's how I ended up working with my first attorney, an Arizona-based attorney.
So you were already familiar with the existence of expert witness work. I've heard from some of my guests, they weren't even aware when they were first contacted that it was a thing. So it sounds like it's something that you were already pursuing.
Yeah, and I was asked on more than a few occasions to sit in on witness prep, not because I was going to be given witness, but to look at how that witness would appear in the court of public opinion. Yeah, well, for example, an attorney would say to me, I've got this person testifying, but it's going to be the media is going to be in that courtroom. Government officials will be in that courtroom. I can coach him on what will come across best legally, but is there anything he's saying that's correct legally that might hurt him from a reputation or public relations or jury relations point of view? And I was able to give him an outside opinion on that. And sometimes just by changing the verbiage a little bit, It's still a strong legal statement, but it also works from a PR point.
Do you find that that also applies to your expert work? Are you kind of changing the manner in which you say something to further the case, or do you kind of just, in your reports or your report, do you just simply state the facts as you know them best? Do you have the outcome of the case in mind when you're generating your reports?
Oh, absolutely. I mean, I got a very thorough briefing from counsel in both of the cases about what they're hoping would be the outcome without trying to prejudice my results, but at least I had a good indication, but in both cases I dug for myself and made sure that I could establish in a factual way that I could defend that my client's side of thing was strong. I said if it hadn't been strong, that's the first thing we would have said. And also I think Erik will tell you that he and I are both very plain talkers. And I think a lot of times the attorneys we work with appreciate that. We don't try to sound like we're pedantic. We don't try to sound like we're talking from 50,000 feet. We work in the trenches.
Mm-hmm.
That's where we talk from.
Do you think that that sort of pedantry can foul you up a little bit? Is that something that you would recommend to other expert witnesses to avoid that kind of thing? Or, how important is it to get super, super technical and specific in your work?
I think it's important to use technical terms when they're the only term that applies, but I think it's very important, and it's something we preach to clients, is a layperson needs to be able to understand this. You need to be able to explain it. And as far as I understand, as an expert witness, a big part of our job is to educate the folks who are going to be reading or hearing our testimony. And so making it so that they can digest it and understand it without going to a dictionary or going and searching online is huge.
How do you stay within those four corners? How do you take your expertise and form it in a way that satisfies what the attorney is asking for without going too far above and beyond, both for billable hours obviously, but also for the good of the case? How do you kind of frame the entirety of your work?
I think it's important to know what you're driving at with any piece of it. With a report, for example, it's important to know the conclusion you're supporting. You don't just start writing a report and go on until you stop at some arbitrary point. You have a specific goal in mind, and you're trying to convince someone that your opinion is correct and support that with fact.
First case that I worked on, Noah, the first place I went was to read opposing counsel experts' reports.
Do you think that it's important that your attorney advise you on who the opposing counsel is so that you can work? Is that important to your work as an expert?
And the judge.
And the judge.
The judge is important to us too, because some judges are very critical of certain types of language or have a previous bias against people in certain professions, or we want to know.
Did you feel adequate, both of you, did you feel adequately prepared going in? Did your attorney do a good job on your first time with writing a report? And in Erik's case, going to depo, did you feel adequately prepared by your attorney for what to expect, what was required of you, when it would be required, all of the things that are involved in being an expert? Did they do a good job? And if not, what would you change? What would you like to tell attorneys, is helpful for a new expert witness?
So I think it really helped me out that I got to go through one where it just went to the report step and then stopped. And then I got to go again through the report and into the depo. But it did help me a lot to work with legal teams who are really willing to educate me on things like I knew what information I was presenting, but the format for litigation is different than most other things we put together, and telling me what kind of experience I could really expect in the room during deposition, preparing me for the curveballs that could come my way. And I think what was really helpful was learning about the Daubert standard. That was a huge aha moment for me to understand the standard that I would be held to even be accepted as an expert by the court. And I think that would be helpful to maybe have known even earlier on, because we did come across it as it went in. But I feel that's enormous for experts. You have to know what to do to make sure you are officially an expert, not just someone writing a report to have it thrown away.
Well, let's talk about that a little bit. What does it mean to you to be an expert? How do you maintain your expertise? How broad and how deep does that expertise have to be? And what can you do to, or what do you recommend that other prospective experts and continuing experts do to remain and maintain that expertise?
A huge part of it is just speaking and writing about what you do. For
Okay.
example, I know it can typically be helpful to have something like a peer-reviewed paper or a book out. I don't personally have that. What I do have are thousands of blog posts that I've written, hundreds of media interviews that can be referenced that show that I do have a method that can be replicated and that is repeatable and that I do repeat. That seems to be a huge qualification. If it's just something you're making up as you go along, that's not going to fly, as we've learned.
So yeah, in 2023, that's being published, right?
Yeah.
Yep.
Blogs
Well,
and the like. Go
and
on.
I did that, and I'm sure Eric probably has it in the future, but I published a textbook from McGraw-Hill,
Oh, okay.
Manager's Guide to Crisis Management, and I also published a media training manual called Keeping the Wolves at Bay. And because I had those credentials out there, you want to be an expert, write a book, then you're an expert. That's for better, for worse, that's the way the public sees it. So if you've written a book on a subject, particularly a fairly niche subject, then or written 1,000 blog posts on it, then you're an expert on that subject.
So you feel that not only is it important to, continue to learn, but it's important to make sure that other people know what you've learned by producing some kind of content.
Yeah, 100%. And I think to be able to answer to your point, something we didn't mention is to continue learning. I think it's very important to be able to say, here's how I continue staying up to date on my field. I read X, Y, and Z publication. That's something I just got asked in the recent deposition I did. How do you make sure you're up to date? How can you actually say that you are using standards other PR professionals use? So it's important to be able to explain how you keep educating yourself too, I think.
So it's interesting you mentioned a standard that you had to become familiar with for your particular case. To what extent is outside research important? So once you're given the case, you're contacted by an attorney or a firm that puts you in touch with an attorney, and they say that you have to know something that's related to your field, but you're not necessarily completely up to speed on. Is it at that point that you say, no, this isn't for me, or is it that point that you say, well, I have enough expertise in this area that I'm going to acquire the specifics that I need for this case? How do you make that determination? How do you draw that line?
For us, the cases that we've worked on are just smack dab in the middle of our wheelhouse. So I
Sure.
think that was helpful. Any tangential things we need to learn, just doing what we do in crisis management, we have to quickly become experts on anything our clients do. So we're very used to becoming, expert for a layperson in almost anything.
There's something that I like to ask everybody. It's actually a couple things, and one of them is winning the case important to you? You as the expert, is it important that you just give the best expertise, or do you have a little bit of a horse in the game? Do you feel like it's important that your side wins?
To me, it's important that my side does the best it can possibly do. Sometimes the expectations are not to win. Sometimes clearly the expectation or the hope is to settle. Sometimes the settlement is a win. In the one roundtable group case I worked in,
Sure.
it was like pennies on the dollar settlement. So that was a
Sure.
win. And so the goal, but we always want the best possible outcomes for our clients, not only because it gratifies us professionally, but because it means they'll come back to us for more.
Before we finish, I do want to pivot to one other thing, which is case completion. Do you feel that lawyers, keep you abreast of where the case sits? Because your piece is one piece of that puzzle, right? So, how do you keep track of where the whole case is? When you get called, it might be at the beginning of the case, it might be in the middle, or it might be towards the end. Does your attorney give you calls? Do you have to track it yourself? Does it even really matter to you?
I think I've had both experiences thus far.
Mhm.
In one of the cases, we were very much a cog in the machine, which is fine. That's just how they operated. I don't
Sure.
know what the conclusion of that case was. Most
Interesting.
recent case I work on, I've been very much kept in the loop, and they did give me not all of the background, but enough of the background so I could know the lay of the land for what I was coming in to do.
Yeah, and it's the same for me. The roundtable group client I worked for, that attorney briefed me very well. Also knew that I was, at that point, an expert witness virgin. So I made sure that I was well briefed and sent me some good links and guidelines to research I could do on the general process. And, so he was very good. But then the law firm that we both worked with directly, that was the one where we never quite, months would go by and we had no idea, then we'd come back with another question, then we wouldn't hear anything again for a while. And ultimately we just heard that something technical had happened and the case was going away.
I take it that doesn't really impact billing so much because do you typically bill by the hour or are you doing by the case? I've had different answers from different people. Do you have a specific method of billing that you recommend for other newer experts?
I think by the hour is smart, just to make sure you're getting paid for your time. These things, much as a lot of our other work in crisis management, are very open-ended. They could need you just for a very specific purpose and you're done, or it could
Sure.
become a drawn-out deal where you're attached and committed. So I think it's smart to make sure you're getting paid for that.
Yeah, yeah, and the nature of expert witness work, it just doesn't lend itself to project billing because you can't accurately predict the amount of time.
Is there anything else you'd like to add for either attorneys or newer experts who are just getting started? Any advice, anything that you wish that attorneys had done better, or that you wish you had known when you had first gotten into it?
I would just say beware academic only credentials, unless you're talking about academia. Because we've now come up against, I've certainly, the first case for both of the cases, come up against people who have, PhDs and master's degrees in this, and they teach here and they teach there. But if you look and whether see they've actually like written a press release for somebody, no, they teach it, but they've never practiced it. And I think that case can be picked apart so quickly that attorneys take a risk hiring. And yet those are the highest paid expert witnesses.
Huh. So you feel that kind of oppositional research is really important and important for the expert witness to be aware of. Is that right?
Yes, and when we did deep dives on the names and backgrounds, and I was encouraged to gently make statements and I asked the question: should I say things that will clearly undermine plaintiff's expert witness's case? And they said yes. And so, portions of my report with the first case I worked on was a detailed diagnosis of why the expert, a detailed analysis of why the two other expert witnesses report were seriously flawed.
And how about you, Eric? Do you have anything else that you'd like to add for attorneys or newer expert witnesses before we sign off?
I don't think you can ever underestimate the value of really good depot prep and role playing. In that, for me, it really some of it was surprisingly in contrast with things I read online, just generic tips on how to be an expert witness. In this last case, they really said, go ahead and fence a little bit more. If you feel comfortable with what they're saying and with your answer, go ahead and hit back a little. And that needed practice. That always needs practice. Even though we teach people to do that in media training, it's a different feeling to be in deposition and to have all the gravity that comes with that. Role play was tremendously important for me.
If you can, give me an example of something that you read online that turned out not to be the case.
So big do's and don'ts list item that I read going in was that you really, as much as possible in a depot, want to just give yes or no answers and not expand. That was a lot of what was repeated online. Now, sometimes that's the case, but often it's much more like the things we preach in media training. You give an answer and then you bridge into saying what you really want to say, if you can. So that was a major difference.
And did you feel that your attorney prepared you for it? Is that something that you were expecting and ready for?
I wasn't at first, which was why I was very happy to do the role play. They opened the gate for me and they set the boundaries for me, right? This is the box you can play in if you're comfortable. But they also gave me the edict of your number one job, which is something we tell clients all the time too, is do no harm. You can't win a deposition, you can only lose it. It was really the main advice they gave. So get it when you can, but don't overreach either.
Tell me a little bit about that role play. What was that experience like? Was it extensive? Was it over a number of days? Was it just an hour long? What was that like?
No, we did a few different sessions, and I think we went several hours each time. And it was exactly what we do in media training, just being on the other side of it, where somebody just comes at you with difficult questions and they tear into you a little bit, right? You can't BS in these things because that's a good attorney's job, and you better believe they will find something to catch you on. And these attorneys did a great job of doing things like dragging up things that I had written in the past that may have seemed to contradict what I had put out. And so once I was able to explain it, they weren't really contradictory. But if I didn't know that was coming, I would have been sweating a lot more in the room.
So for somebody like Jonathan, who's, been doing this for decades and decades and has multiple things written, including books, it's not only important, I take it, to be familiar with the opposing counsel and opposing experts' work, but with your own, right? What if you forget something that you've written before?
Absolutely. And we've seen people pin down on that in the work we've done already, where they quote your own book at you and say, well, you said this in 2015. If you don't have a good answer to that, well, you're probably risking not passing that Daubert standard.
Jonathan and Erik, thank you so much for joining me here today.
Thanks for having us.
And thanks to our listeners for joining us for another discussion at the Round Table.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.